Hi friend, now we'll discuss in this video the strengthen informants and investor protections. So in this video, we'll discuss mainly three parts. One is that Serious Fraud Investigations Officer, that is called SFIO. Second, we'll discuss the fraud reporting requirement. And third, we'll discuss class action suit recognized in the Companies Act. So we'll start now. The first one is the SFIO, called Serious Fraud Investigations Officer. So basically that SFIO is an investigating officers, is an investigating agencies in India carrying out the investigations of serious cases of frauds, and it is under the jurisdictions of the Ministry of the Corporate Affairs, Government of India. So now the questions arise when SFIO can investigate the affairs of the company. That SFIO can investigate the affairs of the company on the following circumstances. First, on receipt of the report of the registrar or inspectors. Second, any special resolution passed by the company to investigate the affairs of the company. In that case, also SFIO can undertake that investigation. Third, the SFIO can suo motu undertake that responsibility on the request of the government in the case of the public interest. And that the last ones, that central government or the state government, they feel that there is need to investigate the affairs of the company. In that case also SFIO can undertake the responsibility of investigations. Here is one very important things we have to keep in our mind, that when that SFIO start their investigations into the affairs of the company, in that circumstances, that whatever the other agency, just for example police or any other local agencies who are in the role of investigating the process, they have to immediately stop their proceeding, and they have to hand over the relevant paper, documents and report to the SFIO officers, so that SFIO officers can undertake that this responsibility, or they can also study of their proceeding of part of the investigation process. Here is also very important part, when that SFIO undertake this responsibility, the company or the its officers of the companies, meaning thereby directors or senior management, they have to fully cooperate to the SFIO officers by helping the documents, papers, or any other informations they need, so that these companies and other officers should cordially cooperate to the SFIO to investigate the affairs of the company. So the important concept of SFIO is basically the investigating officers. They can investigate the serious fraud of the affairs of the company. So this is the briefly I discussed that the first concept of SFIO. Now we can discuss the another important part for reporting requirement. So we have earlier video, in my earlier video, we have discussed that fraud is a new concept. It is elaborately disclosed in the New Companies Act 2013, and that some of the responsibilities has given to the auditors, statutory auditors, or the cost auditor in practice, or the company secretary in practice, or the branch auditor, or the internal auditors. So when in their audit proceeding they find any fraud, they have to report this fraud either to the management of the company or to the central government. So this reporting responsibilities, is posed on the statutory auditor, cost auditors in practice, company secretary in practice, branch auditor, and the internal auditor. But you may keep in mind that where the fraud values of the fraud, means that that if any frauds happen and that values of the fraud are expected fraud amount is more than 1 crores, in that circumstances the statutory auditors immediately they have to inform this fraud to the management of the company, meaning thereby the audit committee or the board of directors of the company. And after getting their response, that statutory auditors immediately reports this fraud along with the report of the management of the company to the government. So it is very important that where the frauds amount is more than 1 crores, that where the auditors can immediately inform to the central government. So in other questions, that what about the fraud where the value of the fraud is less than 1 crores? In that circumstances, the auditor has to report to the management, meaning thereby they have to report to the audit committee, to the board of directors immediately, and they will seek the report of the audit committee or board of directors about the fraud. Okay, and accordingly is that auditor also report in their audit report about the fraud, and the board of directors is also the responsibility in the director's report. When that auditor is qualifying their audit report, they have to respond in their board report about that fraud incident. So the reporting formalities is basically that the fraud where the amount of the fraud is more than 1 crores. So in that case, that auditor's responsibility to directly inform to the central government, and in other case, it is the responsibilities of the auditor to highlight it in their audit report about the fraud with giving of the proper facilities or proper opportunity to the management of the company. So that is the fraud reporting requirement. It is now mandatory in the hands of the statutory auditor, cost auditor in practice for cost audit, company secretary in practice for secretarial audit, branch audit of any branch of the company, and the internal auditors of the company. Now we can discuss that the class action suit is very important part of the class action suit. Is a new recognitions in the Companies Act 2013 because you know that this class action suit, when we realized that when the Sottam computer was Sottam scam was happened in 2009, in that case that Indian equity holders or deposit holder did not take any actions against the company or the management, but on their counterpart in USA, because the Sottam computers was listed in USA stock exchange, and that the equity and the depositors in USA, they take an actions against the companies, against their management in US's code, and they got that the compensations from the companies in that. So after that, in 2000 Companies Act, they recognize the class action suit in the Companies Act 2013, and it's a very important concept, because that class action suit is to be where you have to apply it, because the application for the class action suit has to be filed before the National Company Law Board Tribunal, that is called NCLT. So who will apply to the NCLT, and that applications for NCLT, there are some requirement that if the company is having the share capital, so in that circumstances 100 members or more, or the 100 deposit holders or more, or the 10% of the total number of members or deposit holder, whichever is less, they can approach to the NCLT regarding the class action suit, and if that depositor or the shareholder suspecting that there are something happened which is prejudicial to the companies, or they are suspecting some losses happened to the company, in that circumstances they can apply to the National Company Law Board Tribunal for the class action suit. But that another point is that where the company is not having the share capital, then the 1/5 of the total number of members can apply to the NCLT for taking the actions against the company, against the senior management of the company or consultant, or against the auditors of the company. Because of that, they are suspecting that some injury, some fraud may be happened, or they're expecting that something will be happened which is not good for the company. So in that case, the NCLT will inquire about the situations. They will investigate the methods, and after their investigation, they will give their final verdict. So in this video, we discuss that how you can protect that investors' interest in the three manners. Just for example, we have discussed that SFIO point, that is a very that serious fraud investigation officer. Then also to protect the investor protections, that fraud reporting, because ultimately who will be the sufferer? The investors will be the sufferer if there is any fraud. So that is also to protect by introducing the concept of the fraud reporting requirement to the central government, or if the fraud amount is more than 1 crore rupees, and if it is less than, then that auditor will qualify their report itself. And the last part, we have discussed the class action suit. It's a new concept recognized after the Sottam computer was failed in 2009, but there are some requirement, and that members or deposit holder, the specific members or deposit holder, as per the requirement of the act, they have to approach to the company law board tribunal, NCLT, to take or investigate the affairs of the company and take the remedial measure. So after discussing these three parts, I conclude that this part of strengthen enforcements and investor protection. Thank you so much. Thank you.